Senate will come back to order. Madam Majority Floor Leader.
Mr. President, members of the Senate, we intend to have a full Senate caucus in room W113 starting right now until 2:45. So the Senate will stand in recess until 2:45 with an immediate caucus now in room W113. And if you want to bring Senate File 69 with you and any proposed amendments, that would be prudent. Thank you.
Thank you, Madam Floor Leader. Senate will stand recess till 2:45.
It's a different fluid. Or two.
Good. Senate will come to order. All right. This is the last of the stack, ladies and gentlemen. Introduction and reading and reference of bills. Senate File 22, first reading of the Senate file.
Senate File 22, ground for termination of parental rights guardianship.
Senate File 22 is referred to Committee Number 1, Judiciary. Senate File 160, first reading of the Senate file.
Senate File 160, treatment courts amendments 2.
Senate File 160 is referred to Committee Number 1, Judiciary. Senate File 180, first reading of the Senate file.
Senate File 180, supplemental budgets limitations.
Senate File 180 is referred to Committee Number 1, Judiciary. Senate File 8, or Senate Joint Resolution 8, first reading of the joint resolution.
Senate Joint Resolution 8, political expenditures.
Senate Joint Resolution 8 is referred to Committee Number 1, Judiciary. Senate Joint Resolution 9, first reading of the joint resolution.
Senate Joint Resolution 9, individual right to privacy constitutional amendment.
Senate Joint Resolution 9 is referred to Committee Number 1, Judiciary. Senate File 142, first reading of the Senate file.
Senate File 142, Veterans Home of Wyoming Capital Construction.
Senate File 142 is referred to Committee Number 2, Appropriations. Senate File 189, first reading of the Senate file.
Senate File 189, Uniform Commercial Code Investment Securities Amendments.
Senate File 189 is referred to Committee Number 2, Appropriations. Senate File 191, first reading of the Senate file.
Senate File 191, State Funds, Proxy Voting, and Pecuniary Investments.
Senate File 191 is referred to Committee Number 2, Appropriations. Senate Joint Resolution 11, first reading of the joint resolution.
Senate Joint Resolution 11, Supporting Anti-ESG Litigation.
Senate Joint Resolution 11 is referred to Committee Number 2, Appropriations. Senate File 197, first reading of the Senate file.
Senate File 197, Wyoming Generational Investment Account 2.
Senate File 197 is referred to Committee Number 2, Appropriations. Senate File 194, first reading of the Senate file.
Senate File 194, e-cigarette and vapor material manufacturer licenses.
Senate File 194 is referred to Committee Number 3, Revenue. Senate Joint Resolution 10, first reading of the joint resolution.
Senate Joint Resolution 10, Legislative and Executive Authority, Taxation and Spending.
Senate Joint Resolution 10 is referred to Committee Number 3, Revenue. Senate File 37, first reading of the Senate file.
Senate File 37, Enhanced Concealed Carry in School Zones.
Senate File 37 is referred to Committee Number 5, Agriculture. Senate File 105, first reading of the Senate file.
Senate File 105, An Act to Preserve State Territorial Sovereignty.
Senate File 105 is referred to Committee Number 5, Agriculture. Senate File 192, first reading of the Senate file.
Senate File 192, High Plains Research Station and Arboretum Historic Site 2.
Senate File 192 is referred to Committee Number 5, Agriculture. Senate File 164, first reading of the Senate file.
Senate File 164, Parimutuel Rodeo Definitions.
Senate File 164 is referred to Committee number 6, Travel. Senate File 170, first reading of the Senate file.
Senate File 170, Grizzly Bear Management Prohibition.
Senate File 170 is referred to Committee number 6, Travel. Senate File 181, first reading of the Senate file.
Senate File 181, Eminent Domain Energy Collection Systems 2.
Senate File 181 is referred to Committee number 7, Corporations. Senate File 183, first reading of the Senate file.
Senate File 183, Moratorium Solar and Wind Projects.
Senate File 183 is referred to Committee number 7, Corporations. Senate File 184, first reading of the Senate file.
Senate File 184, Prohibition on Electronic Voting Equipment 2.
Senate File 184 is referred to Committee number 7, Corporations. Senate File 190, first reading of the Senate file.
Senate File 190, Election Transparency.
Senate File 190 is referred to Committee number 7, Corporations. Senate File 179, first reading of the Senate file.
Senate File 179, Sage Grouse Compensatory Mitigation Amendments.
Senate File 179 is referred to Committee number 9, Minerals. Senate File 167, first reading of the Senate file.
Senate File 167, Board of Chiropractic Examiners Criminal History Records.
Senate File 167 is referred to Committee number 10, Labor. And that is all the Senate files, ladies and gentlemen. Do we have any re-referrals? Senator Barlow.
Thank you, Mr. President. If there's no objection, I'd like to re-refer Senate File 187 to your Committee number 2. Senate File 187 to Committee number 2. And I'd like to re-refer Senate File 157 to Committee number 1. Senate File 157 to Committee number 1. Thank you, Mr. President.
Yes, I bet I know what you're going to say. Senator Nethercott.
Got to state the catch titles.
Got to state the catch titles.
Mr. President, could I re-refer Senate File 187, Public Employee Retirement Plan Contributions, to Committee number 2? And Mr. President, could I refer, without objection, Senate File 157, Department of Family Services Confidentiality Amendments to Committee number 1? Thank you, Mr. President.
Okay. Absent objection, Senate File 187 is being re-referred to Committee number 2, Appropriations. And Senate File 157 has been re-referred to Committee number 1, Judiciary. Okay. On to reports from standing committees.
Mr. President, the following reports are dated January 29, 2025. For Committee number 4, Education, to whom is referred Senate File 131, Charter School Leasing, respectfully report same back to the Senate with a recommendation that it do pass amended. Ayes, Senators Brennan, Olson, Rothfuss, Schuler, and Scott. Senator Schuler, Chairman. For Committee number 7, Corporations, Elections, and Political Subdivisions, to whom is referred Senate Joint Resolution 4, Resolution on Commercial Baseload Power Generation, respectfully report same back to the Senate with a recommendation that it do pass. Ayes, Senators Boner, Case, Dockstader, and Steinmetz. No, Senator Landon. Senator Case, Chairman. Your Committee number 7, Corporations, Elections, and Political Subdivisions, to whom is referred Senate File 146, Consumer Rental Purchase Agreement Act Amendments, respectfully reports same back to the Senate with a recommendation that it do pass. Ayes, Senators Boner, Case, Dockstader, Landon, and Steinmetz. Senator Case, Chairman. Your committee number 10, Labor, Health, and Social Services, to whom is referred Senate File 130, Emergency Assistance Immunity, Mental Health Services. Respectfully report same back to the Senate with a recommendation that it do pass. Ayes, Senators Barlow, Crum, Hutchings, and Scott. Excused, Senator Steinmetz. Senator Barlow, Chairman. Mr. President, your committee number 10, Labor, Health, and Social Services, to whom is referred Senate File 147, Service Dogs, Training, and Crimes. Respectfully report same back to the Senate with a recommendation that it do pass. Ayes, Senators Barlow, Crum, Hutchings, and Scott. Excused, Senator Steinmetz. Senator Barlow, Chairman. Your committee number 4, Education, to whom is referred Senate File 126, Establishment of a K-8 Public Lab School. Respectfully report same back to the Senate with a recommendation that it do pass amended. Ayes, Senators Brennan, Rothfuss, and Scott. No, Senators Olson and Schuler. Senator Schuler, Chairman. Your committee number 7, Corporations, Elections, and Political Subdivisions, to whom is referred Senate File 145, Local Governments, Investments, and Equities. Respectfully report same back to the Senate with a recommendation that it do pass amended. Ayes, Senators Boner, Case, Dockstader, and Landon. No, Senator Steinmetz. Senator Case, Chairman. Your committee number 9, Minerals, Business, and Economic Development, to whom is referred Senate File 143, Public Monies, Deposits, and Credit Unions. Respectfully report same back to the Senate with a recommendation that it do pass. Ayes, Senators Cooper, Jones, Nethercott, and Rothfuss. No, Senator Anderson. Senator Anderson, Chairman. Your committee number 9, Minerals, Business, and Economic Development, to whom is referred Senate File 135, Defense of State Banking 1. Respectfully report same back to the Senate with a recommendation that it do pass amended. Ayes, Senators Anderson, Cooper, Jones, Nethercott, and Rothfuss. Senator Anderson, Chairman.
Thank you, Randy. Any other announcements? Any other reports? Nope. Okay, Madam Majority Floor Leader, we are at that order of business. Consideration on bills on general file.
Mr. President, I move that the Senate resolve itself into committee of the whole.
You have heard the motion. All in favor say aye. Aye. All those opposed, no. Okay, motion is carried. Senator Brennan's in charge, but first, we give you Senator Hicks because Senator Brennan has a bill up first on committee of the whole. So Senator Hicks, come on up.
Committee of the Whole, please come to order. The first bill for your consideration is Senate File 71. Reading clerk will read the Senate file.
Senate File 71, Ignition Interlock Restricted License, Aggravated Homicide, an act relating to crimes and offenses sponsored by Senator Brennan, was referred to committee number 10, which returned a committee recommendation that it do pass. Ayes, Senators Barlow, Crum, Hutchings, Scott, and Steinmetz. Senator Barlow, Chairman.
Senator Barlow, you've heard the reading of the bill. What's your pleasure?
Mr. Chairman, I move in the committee of the whole rise its report. It do so with a favorable recommendation of Senate File 71 and turn the explanation over to Senator Brennan, and I'll double check on a standing committee amendment.
Senator Brennan.
No.
Thank you, Mr. Chairman. Mr. Chairman and body, what we have is Senate File 71, Ignition Interlock-in Restricted License, Aggravated Homicide. This is an opportunity for both some criminal justice reform and maybe the opportunity to correct a mistake made earlier in previous legislation. So first of all, let me say we are dealing with homicide by vehicle and aggravated homicide by vehicle, which are serious offenses. However, as statute is written currently, I believe we need to make a couple of adjustments to this part of the bill on being able to get a license back. So as things are written now, if somebody has an aggravated homicide and they have a blood alcohol content of 0.08 and 0.14 for a first offense of driving under the influence, they're eligible to obtain a license after the required revocation period of 1 year. However, in 2019, the Wyoming statute 31-7-402 was added and to the state that a person shall not be eligible to receive a regular license until they have held the ignition interlock-in license. And so with some of that wording, then we have somebody who is convicted of a blood alcohol content of 0.15. They're not eligible for the ignition interlock-in license during the period of revocation, and because they're not eligible for that license, they're not eligible to get a license back ever in this or any other state. It's believed that this was probably an oversight, but either way, I think it's worth us taking a look, and hopefully you'll agree with me that we can get ignition interlock-in licenses back for those that blow a 0.14 or more. And I'll take it. Any questions?
Are you ready for the question? All those in favor of Senator Barlow's motion, and with the committee of the whole rise and report, that to do so with a favorable recommendation on Senate File 71, say aye. Aye. Those opposed, no. Senate File 71 has passed the committee of the whole. The next bill for our consideration is Senate File 91.
Senate File 91, Petrograph and Historic Inscription Protection, an act relating to crimes and offenses and state lands, sponsored by the Select Tribal Committee, was referred to Committee Number 6, which returned a committee recommendation that it do pass amended. Ayes, Senators Jones, Landon, and Schuler. No, Senators Boner and Hicks. Senator Landon, Chairman.
You have heard the reading of the bill. What is your pleasure? Senator Landon. Oh, sorry.
Thank you, Madam Chairman. I would move that when the Committee of the Whole rises to report it, do so with a due pass recommendation on Senate File 91, Petroglyph, Pictograph, and Historic Inscription Protection. There is a standing committee amendment. I'd ask that that be read in at this time.
Senate File 91, Standing Committee Amendment Number 1, page 1, line 4, delete.
Madam Chairman, I would go ahead and move the standing committee amendment. For a description of the bill and the standing committee amendment, I'd ask that you call on the good senator from Sweetwater County.
Madam Chairman, this is a bill that was brought from Tribal Relations, Select Committee on Tribal Relations. It's creating a misdemeanor offense for injury to petroglyphs, pictographs, and historic inscriptions, providing some penalties, and allowing for a survey of these pictographs on state lands, and it does also provide an appropriation. For a definition, a petroglyph is an image created by removing part of a rock surface by incising, picking, carving, abrading, and it is a form of rock art. A pictograph is used in the earliest forms of tribal entities, and it is usually a chart, a graph, or something that is a picture. And this bill basically is allowing, if something is defaced, the bill states that it's a misdemeanor, and the fine would be not more than $750. and this is where the amendment will come into play. The amendment does lower the fine from not more than $750 to less than $25 or more than $100, and possibly 6 months in county jail, and they would have to relinquish all the artifacts or materials that they gathered. The appropriations in this is $441,340, and that would go to the Department of State Parks and Cultural Resources. With this money, they'll be surveying, documenting, and creating three-dimensional modeling, and the money is to pay for archaeologists and their travel, people to process these things, and to upload and scan the documents. And I do want to stress that this is only on state lands. There was some objections brought up to this bill, but we're trying to preserve tribal history on state lands. And I'll stand for any questions.
Senator Case?
Thank you very much, Madam Chairman. Madam Chairman, I was on the Tribal Relations Committee that came up with this bill, and I would stand here and ask you to defeat the Standing Committee amendment. And I'd like to tell you a little bit about rock images. It's not called rock art necessarily because it's not necessarily an artistic endeavor. It's storytelling, and it is communications. It's communications by people that have way predated the state of Wyoming and way predated the Columbian expansion and so-called discovery of America. These people of different tribes, different cultures, have been here for thousands and thousands of years. You know, we talk about a Clovis culture, that's usually, they used to think the limits was something like 16 to 18,000 years ago. They've now pushed the limits up into the 20s and higher as to the amount of ancient people that were on this landscape. But this isn't just about the work of ancient people. It's also about ancestors that were in this room. The largest migrations in the history of the United States occurred in Wyoming, crossing on our trails going to Oregon and to Utah. They left visible reminders of their journey across. You can see Jim Bridger's carvings in rock on state land. And it's insulting to think that someone could destroy that and face a fine of between $25 and $100 against the amendment.
Senator Kolb?
Yeah, thank you, Madam Chairman. On and against the amendment. The reason is first off, it's extraordinarily difficult to catch people out there. We've got a lot of these in Sweetwater County, and they are irreplaceable. And I think to try to catch some folks out there is just a monumental undertaking. So to lower the fine down to this low amount, I find just, frankly, just not appropriate. These are things that are irreplaceable. Frankly, they deal with a lot of things with erosion in these areas. But to find somebody who's actually taken these and to only fine them this minuscule amount, it's not much of a deterrent. I think the fine needs to be where it was, if not more. So just like to speak about that. Thank you, Madam Chairman.
Senator Craigo?
Thank you, Madam Chairman. So the amendment actually is a conforming amendment, and so that's existing statute. The new penalties contained within the bill, which is much, much higher. So hopefully that helps answer some questions. I actually think it's a good amendment. It creates a conforming amendment so that the new penalty within subsection E is its own penalty exclusive of the penalty that's already in the green books in subsection A.
Madam Chairwoman, I apologize. Thank you for that. Thank you for making that explanation. I'll take a deep breath here. So I support the amendment, but I'd like to talk about the appropriation and the efforts to document this these important archaeological sites, but let's do that after the amendment. So I'd call for the question on the amendment. Support it.
Right. Question has been called. All those in favor of Senator Landon's motion to adopt the Standing Committee Amendment Number 1 to Senate File 91, please say aye. Aye. Opposed, no? The motion is adopted. All right, back on the bill. Senator Jones.
Madam Chairman, just to speak to a little bit of the appropriation, so I can line it out a little bit. There are 120 sites identified that they want to start with at this time. On average, 3 days of work at each site with travel for a senior archaeologist and a technician. And then they will be uploading photos, scanning, digitizing them, transcribing notes, making maps, entering data. And then an additional employee will be doing the creation of the three-dimensional model. And that does also include a helper with that. So this is, especially the 3D model, this is a pretty giant undertaking, and I do think it's extremely important that we record, and also this 3D model will allow people who can't actually travel to these sites, because a lot of them aren't just accessible, even though they're on state lands. They can actually see what's happened there and the historical significance.
Senator Case.
Thank you very much, Madam Chairman. I'd like to talk a little bit about this. The new techniques that are around for imaging and have actually created new discoveries. So I don't know if you guys have followed, but there's this imaging technique that they have now used on scrolls that they found at Pompeii. There was an entire library that had these charred remains of scrolls. And for 200 years, people have been trying to figure out how to read those scrolls. And they would soak them in water, and then they'd lose them, unravel them. They couldn't unravel, it all disappeared. They now have imaging techniques where they can take a scroll, image it, and use artificial intelligence, and they're beginning to read these scrolls from an ancient library, like the library at Alexandria, all in carbon-encased things that look like a little brown stick. The same kind of artificial intelligence can help. You could look at this wall here and you'd say, there's nothing there. There's nothing there. Nobody passed through here. It's not important. You can find remnants of an image, and you can find a whole panel if you've got the right techniques to use different wavelengths of light. You can use imaging that looks at the surface texture, almost a radar type thing, or to apply artificial intelligence to try to put it all through together, and it's amazing what's there. We have great sites in Wyoming, some we don't even know about. Sinks Canyon is where I became very interested in this because of the evidence there. The Dinwiddie's another place. They have now found out that people lived in the high mountains all year round. Try that today, you guys. So, but the problem, Madam Chairwoman, is that this stuff is being lost. It's eroding. The pH of precipitation in some cases has changed. Some cases there's pollution. And so we're losing these sites forever. Sometimes they're vandalized. That's the most tragic part. And these aren't just ancient sites. They're relics and remnants of the memories of our Oregon Trail experiences, the Mormon Trail. And so the important thing about doing this now with the sites we know is that imagery and that documentation we'll have it forever. And in 100 years, people could relook at that data and maybe find something new. It's irreplaceable. It's not a lot of money. I ask for your support.
You ready for the question? No, we are not. Senator Boner.
I do have a committee of the whole amendment, Madam Chairman.
What's that?
I have a committee of the whole amendment. Can we get that?
Oh, yes.
Senate Bill 91, Committee of the Whole Amendment Number 1, page 2, line 13, after.
Thank you, Madam Chairman. I move committee of the whole amendment number 1 to Senate File 91 and ask for the body's favorable consideration. Ladies and gentlemen, we did have a robust discussion in committee about the laudable goals of this bill, but striking a balance between those goals and protecting private property rights. We heard some testimony on this floor that this only applies to state land, but actually that's not what we heard in committee. The fact is that oftentimes you have isolated state parcels that have no public access to them, but it's a position of the Office of State Lands and Investments that they have access to those isolated parcels over individuals' private property as a term of the lease. So I thought it was really important to introduce a little bit more balance into this discussion if we're going to be going out and documenting these historic artifacts. And just to be clear, when an archaeologist goes out and documents these artifacts, there's nothing guaranteeing, in fact, I almost guarantee the opposite, that they're going to go out and document more than just the pictographs that we heard, the great history from my friend from Fremont County talking about. They'll document everything they see, anything that's more than 50 years old. That's their job, that's what they do. And that has caused some tension in my neck of the woods when it comes to the federal leasing process for oil and gas. There's been some serious disagreements as to the level of involvement our federal partners have, say, on private property if they're surveying for a oil and gas well that is on private property, drills down into private or state minerals, but hits federal minerals at some point in that well bore. So just want to make sure the body's aware of that, that when you identify these sites, it does have a regulatory impact on important parts of our agriculture industry as well as our energy industry. So what the amendment does, Madam Chairman, is it kind of tightens down the bill, making sure that we do take into account private property rights, recognizing that the surveys will be limited to what we're all thinking about, the documented in the Cultural Records Office's archaeological site database. You have a handout, has a nice little map of the state that shows you exactly where those sites are. And also making sure that you have to get permission of the landowner to cross private property. So I'd like to think that's a relatively modest ask, Madam Chairwoman. And I just want to make sure that we have a good balance in this bill and we take all the factors into consideration. So I'll stand for questions on the Committee of the Whole amendment.
Senator Landon.
Madam Chairman, I just want to thank the senator for a good visit yesterday and again this morning. This is a very reasonable amendment to this bill. And like he says, I think it gives some needed balance. I can't imagine that we would have a crew that would come out and run across private land. This just assures that they're not going to do that. And so I'd ask you to support the amendment. Thank you.
Senator Rothfuss.
Madam Chairman, I do have a question about it, though. You know, this is a state entity that is intending to go and image and render the specific historical features. And as I understand the amendment, if there were a fully landlocked parcel, but it was state land, so this is a piece of state land, as I get it, or as I understand it, the amendment would say that the state is not allowed to access the state land without permission of the landowner. And I know that we have a lot of talk about the public not being allowed to access the state land without permission of the landowner, but I guess this is the first time I've heard of the premise that the state is not allowed to access state land without the permission of the landowner. Am I reading that right? And is this something we've done before? Because honestly, that's a whole new approach to me, where we're denying access to the state to state lands. That seems like we're leveling up that procedure. So am I understanding that correctly for the second half of the amendment?
Senator Boner.
Madam Chairwoman, yes, for this very limited circumstance, that is what's in the amendment. What we heard in committee, it's not just, the terms of the lease, you expect to have state lands have access to, go and take it and check out the isolated school section. That remains unchanged. But what we're talking about here with this particular bill is not just Office of State Lands personnel, but additional archaeologists beyond just our state lands office going and accessing not just the state land, but private property as well. So yes, that's exactly what it does. There's concerns Like I said, once you get archaeologists out there, they're going to document more than just what they're out there to document. They're going to document everything. That may include private property. It's a very sensitive topic, and I hope that we can support the amendment, recognizing that it is very limited to this specific circumstances, not a broader policy statement about access to state lands.
Senator Rothfuss.
Yeah, Madam Chairman, and I appreciate the explanation. I'd ask that the amendment be divided. I know that's exactly what you were looking for as Chairwoman. Madam Chairman, lines 1 through 6 would be the first division. Lines 7 through 10 would be the second division. And I'd start by speaking on the first division, if you find that divisible.
Believe they are divisible.
Great. On the first division, looks good, vote aye.
Okay. All those in favor of Senator, this is on Division 1.
Correct.
Senator Case.
What's wrong with looking for new pictographs or on our state land? What's wrong with that? If we find something that we can document and save from erosion, and nobody's ever seen it before, it's never been documented, honestly, what's wrong with that? Help me here. Priceless information that can tell us more about cultures that lived here, that we just didn't see it. Against this division.
We'll go Senator Hutchins and then Senator Boner.
Thank you, Madam Chair. On and for the amendment. I kind of like the fact that you have to get permission to go on someone's private land. I'm sorry, was that the second one? I'll wait to the second one then. Thank you.
Senator Boner.
Thank you, Madam Chairwoman. I guess I'm coming from a perspective, we have to keep in mind that if you're talking about things that are allowed to be registered in a database, it's not always, it's rarely, these very rare, by definition, historic items that we're talking about here. Anything more than 50 years old is eligible. So this opens it up wide open. You can have a spent rifle cartridge that may be more than 50 years old. That's going to be documented, and as I stated before, could be used as a way to slow down important economic activity. That's, as I explained before, we have to understand that it's what things that qualify for historic preservation, that's the cutoff, 50 years or older. It's not, and it's very mundane things, unremarkable things. So that's based off of my experience as a citizen, more than a legislator, Madam Chairwoman. That's the perspective that I bring, is how this applies in real life.
Thank you. Senator Barlow.
Thank you, Madam Chairman. So I've too experienced that, and I'm comfortable with this language in this bill because it talks about two specific things. Not all the other things that you might find that have some historic significance, but only petroglyphs and pictographs. We're talking about that specific purpose, no other purposes. I certainly understand my colleagues' concern about the Office of State Historic, et cetera, and national registries, but this is very specific to just those two items. So I'm comfortable. I don't think that the division is necessary. I don't think the entire amendment is necessary, but this division I don't think is helpful to the bill. Thank you.
Senator Hicks and then Senator Case.
So this very question came up because I asked it of the cultural resource folks, and I said, why don't we include other things on there like arbor glyphs and other historic structures and stuff? And they said, that's not the intent. The intent is specific to these type of rock art that are out there. They said, this is what the budget's for. If we want to go out there and do reconnaissance surveys to try to find all these other things like arbor glyphs and historic structures, it's going to cost a whole lot more on this. The intent is known, arbor glyphs and petroglyphs, to go out there and be able to catalog those, record them. That's what the budget was for. That's what they said they were planning to do. They weren't going to go out there and do all of these other surveys. Specifically, they said that would be a significant increase in the cost in this budget to do that.
Senator Case.
Thank you very much, Madam Chairwoman. So the budget's going to be fixed, you guys. They can't get any more money. They might come back later and say, we need more money because we found some things. But here's the problem. Madam Chairwoman, these sites are known in different ways. They're not known by being documented in the Wyoming Cultural Records Office Archaeological Site Database and located. That's not necessarily where they all are. They could still be known, but not documented there. Do you understand my point? And one of the reasons they might be known, but not documented, is because one of the ways to protect these sites is not to disclose their location. And we will talk about that a little bit more, but scholars should have all the information if you have a purpose. But it's not necessary all the time that the general public know the location of all these sites and that be available publicly, because that can lead to vandalism. It's a very unfortunate thing. So I don't understand the contribution that's being made by Division 1 of the amendment. I think that exists fine in the bill that says all known. Thank you, Madam Chairwoman. Ask you to vote no.
All right, all those in favor of Senator Boner's motion to adopt Division 1 of Committee of the Whole Amendment Number 1 to Senate File 91, please say aye. Aye. Opposed? No. The division has failed. Now for Division 2. Senator Rothfuss.
Yeah, Madam Chairman, thank you. And on Division 2, I have concerns about the idea of excluding state agencies from state lands. And I am sensitive to the concerns of the private property owners. And I think this language could perhaps come back on a second reading amendment to ensure that there's coordination, because we do want to be sensitive to the interests of the private property owner. But I think that's the case right now with state and agencies entering state lands, that they do have to coordinate that. They've got some sort of access agreed upon. We already have challenges, and I think this is a continuing issue of contention in the state, that the public does not have access to an incredible amount of public land. And we hear that concern, and we know that our hunters and fishers and public land enthusiasts are quite upset about being denied to these landlocked parcels. And we continue that debate. But on this, the idea that we're going to say, all right, well, we really don't want anyone on this public land, this state land, and we're going to deny the state access to it under this situation. I think that's just a bridge too far for me. I am confident that the state would work with the landowners. And, Madam Chairman, as I mentioned, I could certainly support an amendment on second reading that discussed coordination with the state office to ensure that there was no damage, or that it was consistent with the desires of the landowner that they're passing through. That's perfectly reasonable to come up with some language that governs that. But the idea of denying the state access to state lands is a bridge too far. Thank you, Madam Chairman.
Senator Driscoll and Senator Hicks.
Madam Chairman, adding on to that, I think administratively there is no way to block the state from their own ground for administrative purposes. And I think as a leasing of state ground, you don't have the right to stop them from getting in there. That's part of your lease, is you're gonna help them provide access. And I can say from my end, maybe it's happened different up in the middle of the state, but where we're at, the state's been very good about letting us know when they're coming and how we'd like to see them do it. I think this actually causes some unintended potential conflicts between state land leasees, private landowners, and other. Best of my knowledge, the state never tries to go to state ground across private ground unless they have some kind of terminology in their lease or they do it ahead of time. If they're doing it differently, I believe they're breaking the law. They can't just go willy-nilly pick where they want to go. I think they have to get a hold of that leasee because that's their methodology to get there. Maybe there's some unleased sections out in the state that they don't have access to. I don't know about those. But in our area, I can tell you it would cause some heartburn between the state and us probably if I tried to deny them access to come. And for us, it's been archaeological, but it's also been weed surveys. It's been looking at grazing patterns. I think I'm wearing two coats here. One of them's a private landowner. The second one is as a steward of the state grounds, and they've got every right in the world to know culturally what's on their grounds, to know what's happening on them and how they are. And if not, my suggestion would be that they probably sell them to somebody else or find a different way to do them. So I stand opposed to this. I don't think this is good legislation.
Senator Hicks?
Yeah, Madam Chairman, I think we can tighten this up. One of the reasons that this come out is because in the testimony that we received basically from the Office of State Lands is, well, we'll just use your grazing permit to force you to give us access across your private property. Maybe this wasn't the most artistic way to address that issue of the, we'll just force you because you have a lease on this state land that's going to give it. So I understand we maybe need to address this language, but I want to make one clarification. These are not public lands. We should never confuse institutional lands that belong to the trustees. These are typically state school sections are not public lands. Institutional lands are not public lands. And I just want to make that distinguish because we get this confusion all the time that the public thinks that they're public lands and have right of trespass. They do not. They are institutional lands. And it's nuanced, but it is very important that we make that distinguish when we have these discussions.
Senator Boner?
Thank you, Madam Chairwoman. On and forward, Division 2, let's be clear about what this does. We're not talking about limiting access of state employees to state lands under regular circumstances. What's contemplated in the bill currently is this idea that it's not going to be necessarily a state lands office employee, it's going to be a third party. And that does cause problems, anecdotally, in central Wyoming. It has, for industrial purposes. I hate to see something similar happen with this program, where if you have, say, a third party going out and doing this work, there is a lack of communication and frankly a lack of respect with the leaseholder. And so that's the reason for Division 2. If we want to talk about, make sure they coordinate, that's important. That gets to a lot of the concerns. Because you can imagine the trouble that happens, say, if you just go through somebody's calving or lambing pasture without talking to them, that causes real harm, and it's unnecessary harm to the landowner. But let's be clear about what we're talking about here. This is not, just your everyday state employee going out and doing their due diligence on state lands that, of course, they do have access to. So this is different. Let's keep that in mind. I hope you can support this division for that reason. Like I said, I'm just looking for a little bit of balance in the bill.
Senator Driscoll, then Senator Rothfuss, and Senator Pearson.
Madam Chairman, thank you. I don't disagree with what was just said, but that's not what this division says. I'd suggest we defeat it and bring back one that's worded much clearer. Is when a contractor comes on, they are a part of the state. If they're there and they're at their request, they're actually a division of it. So if you're going to do it differently, you really need to state it a little differently, because when whoever it is, if they have the permission of the actual owner of the ground and they're a part of it, they're on official administrative business, they're no different in the eyes of the law, in my belief, we're looking at some lawyers, than an employee of the state. So I think we ought to tighten this up and get it, because I really do get it with contractors. The contractors are somewhat different than a state employee is, and I'm happy to support that. Thank you.
Senator Rothfus.
Thank you, Madam Chairman. I just wanted to push back on the idea that these are not public lands. They're absolutely public lands. We are the public. We own those lands. The Constitution literally refers to them as public lands. Now, we do all understand that these are lands that are in trust of the state for the schools. Typically, the revenue off of them are for the schools. But the idea that they're not public lands is certainly contrary to the constitutional intent. This is about the people of the state of Wyoming. These lands are their lands, our constituents' lands. It's not held separate from them for the benefit of a small number of people. It belongs to everyone in the state. And the idea that we're denying access even to the state itself is antithetical to that purpose, right? We believe in the multi-use of public lands. We believe and understand that we need to gain revenue from these lands for our public schools. But the idea then that we can claim that it's just for a select few and we can deny public access to it is again quite contrary to Article 18 of the Constitution, Madam Chairman, which is about public lands.
Okay, Senator Pearson and then Senator Jones.
Thank you, Madam Chair. So my feeling on this as a landowner, I like this division. Whatever happened to being a good neighbor like it used to be? You know, where when you're gonna cross someone's land, you call them and say, can I cross your property? Things like that. I have trouble with the state coming in because the state owns all the water and then thinking that they have a right to go onto our land where the water is and conduct whatever surveys they have without asking us first. I mean, it's just a common courtesy. It wouldn't be that hard for these people to get a hold of the landowner and say, we're collecting this data and we just want to let you know that we're gonna be crossing your land. I don't see what the issue is with that. It's common courtesy, keeps everyone happy and friendly. On for the amendment, thank you.
Senator Jones.
Madam Chairman, we had this discussion in committee, and they assured us that they are accustomed already to checking with the landowners and can schedule around sensitive time periods and make sure that they are accessing it when it's best for the landowner.
Ready for the question?
Question.
All those in favor of Senator Boner's motion to adopt Division 2 of Committee of the Whole Amendment Number 1 to Senate File 91, please say aye. Aye. Opposed?
No.
The motion to adopt Committee of the Whole Division 2, sorry, thank you. Division 2 of Amendment 1 to Senate File 91 has failed. Division has been called. All those in favor of Division 1, please stand. Division 2, sorry. Okay. All those opposed to Division 2, please stand. 16 aye, 14 no. So the motion to adopt Committee of the Whole, Division 2 of Amendment Number 1 to Senate File 91 has passed. We are now back on the bill. Senator Landon.
Madam Chairman, just real quickly, I'm glad we got through all of that. I honestly think that it will be worked out across our lands on this issue, and I can't imagine a crew going out there without working with the landowners. So, but we've got that in the rearview mirror. I hope everyone will support this bill. I think the senator from Fremont County articulated it very well. He's served on the Tribal Relations Committee for a long time. This is probably long overdue. I know of a couple of these sites, and I worry about even telling people where they are. They're spectacular. And it would be a heartbreaker if we don't get these cataloged and in. I really commend the work of the former senator who helped to chair the Tribal Relations Committee. She and that committee did a great job. Hope you'll support the bill. Thank you.
Question on the bill. All those in favor of Senator Landon's motion that when the Committee of the Whole rises to report that it do so with a favorable recommendation of Senate File 91, say aye. Aye. All those opposed? Senate File 91 has passed Committee of the Whole. The next bill for our consideration is Senate File 96.
Senate File 96, Wyoming Gold Act, an act relating to the Wyoming Legal Tender Act, sponsored by Senator Ide, was referred to Committee Number 3, which returned a committee recommendation that it do pass amended. Ayes, Senators French, Ide, and McEwen. No, Senators Case and Pappas. Senator McEwen, Chairman.
You have heard the reading of the bill. What is your pleasure, Senator Ide?
Thank you. Oh, Senator McEwen moves the bill.
Oh, what is your pleasure, Senator McEwen?
I move that when Committee of the Whole rises to report, it do so with a recommendation that Senate File 96 do pass. And to explain this bill, I will call on Senator Ide.
Senator Ide.
Thank you, Madam Chair. There is a standing committee amendment on this. I'll go ahead and have it read in. All right, go ahead and read it in, and then I'll move it at the end of the explanation here. Thank you.
Senate File 96, Standing Committee Amendment Number 1, page 2, line 3, delete.
So, for the new members here, brought this bill a couple of years ago, and it's been scaled down substantially. It's a real simple bill. I'll go ahead and just start in, and we'll go through this. I'll move the amendment, then I'll kind of explain a little more in detail. But, the catch title here pretty much explains everything. It's the Wyoming Legal Tender Act that we're playing off of here. And that was passed in 2018, which put Wyoming #1 on the Sound Money Index nationwide by making specie legal tender untaxable and legal tender in the state of Wyoming, and that vaulted us to the top. So I'm trying to keep us at #1 on something that's kind of interesting and good economically for the state. So if you go into section 1 here, the meat of this bill is right there in Romanet I, and it says holding not less than $10 million in specie and specie legal tender. The primary concern here is just what it says from there: for the purpose of diversifying the state's investment portfolio, preserving capital, and ensuring against inflation. I'd like to conversation that we had down in caucus here just a little while ago, debt defaults and other risks. The rest of this, if market conditions warrant, the treasurer could invest in precious metal leases or bonds that are payable in precious metals. The state treasurer may contract for services with established precious metals firms and other industry experts to assist with the duties of the treasurer. The treasurer shall require financial disclosure along with other requirements specified by the state treasurer. C there, the state treasurer shall adopt the rules necessary to implement this section. Section 2, the treasurer shall adopt rules necessary to implement this act. And then section 3, there again kind of goes into some of the key language in this bill. The state treasurer shall conduct a study analyzing the role of precious metals in augmenting, stabilizing, and ensuring the economic stability and prosperity of the state and the families and residents and businesses of the state. The study under this section shall include a review and methods of the state to begin accepting gold and silver as payment. And that's, we kind of want to start looking at the plumbing here to hold precious metals and further that if need be. The last statement there, the treasurer shall submit results from the study with recommendations for legislation requesting the study to the Joint Revenue Committee during interim. So, that study, Utah did something similar here. The study really isn't going to cost anything. I've talked to the treasurer. We've got places where they can have outside parties that will effectively do this study for free with other states that are actually putting precious metals, gold, into their treasury of their state. So right now, Madam Chair, I'd like to go ahead and move the amendment. So I move Standing Committee Amendment number 1 to Senate File 96 and ask for your favorable consideration. So all this is a little bit of cleanup. There's only 2 spots in here some recommendations from the Treasurer's Office. On page 2, the original language said on line 3 and 4, it said 10 million in specie and specie legal tender between and across all state managed accounts. The treasurer said it would be best to just change that to in the Permanent Mineral Trust Fund. So that's the first amendment. And then on page 3, this is all one amendment. The second part of that first amendment is on line 19, where it says committee, and they wanted to add capital financing in there. So capital would be included in that language on line 19 of page 3. So that's all there is to that amendment. And can we go ahead and vote on the amendment? Madam?
Question? All right, all those in favor of Senator Ide's motion that when the committee of the whole, wrong lines. All those in favor of Senator Ide's motion to adopt the committee of the whole amendment number 1? Standing Committee Amendment number 1 to Senate File 96, please say aye. Aye. Opposed? The motion to adopt the Standing Committee Amendment number 1 to Senate File 96 has passed. We are back on the bill. Senator Ide.
Thank you, Madam Chair. So I'll get into sort of the history of this and why this is a good bill and why you should vote for it. Back in 2023, when we actually got this out of the Senate and it headed over to across the hall here and ran into some headwinds there. So learned from that, scaled this way down, just making it a minimum of $10 million that the treasurer shall purchase so we can kind of get started and start learning about how precious metals could be implemented into our treasury here, our sovereign wealth reserve accounts. And it's just such a small amount. I mean, it's 0.0003 of the total that we have. And I think it's a good start. You know, Utah, they passed a bill similar to this. They've already purchased about $40 million worth of gold to store, to add to their treasury there. So, but just some statistics. And all I'm really shooting for here is, there's a little flyer I put in your basket there, and it really helps show how, you know, gold tracks with deficit spending. And that's what this investment is about, effectively, is to an insurance policy against the, you know, the monetary racketeers back on the East Coast that are just, you know, devaluing our currency just relentlessly. And back in this was 2 years ago, our national debt was $31.4 trillion. Today, it's almost exactly $5 trillion more than it was just 2 years ago. The price of gold was at $1,800 an ounce. Now it's $2,700, almost $2,800 an ounce. And I'm not trying to be an investment pro here. I'm just looking to see what our best hedge is against the inflation tax that was mentioned by the good chairman of revenue in our caucus down there. This is tested time. You can see on the chart from 1970, that was when we first depegged from gold, that all currencies went on. Our currency was the last currency pegged to gold, and Nixon took us off it in 1970. And that's when, you know, we're on purely a fiat currency, the full faith and credit of the government. And you can just kind of see from this chart, it's a real good chart that just shows how gold tracks that inflationary money printing machine that they have back on the East Coast. So that's the real crux of this whole bill, is just to protect our state wealth in some fashion and get the treasurer to looking at it. You know, the CBO report, I've got the report from the CBO just about a week ago, and they're projecting, we're at $36.4 trillion right now. In 10 years, they're projecting, with everything remaining equal, no recessions or anything, another $24 trillion to our national debt in just 10 years. So, you know, if gold tracks like it has for the last 100 years since we got the Federal Reserve, it looks like it's going to be a good safe haven bet to protect our wealth in this state. And it's a minimal amount. You know, $10 million of gold will fit in the trash can sitting next to you on your desk here. A 400-ounce good delivery bar, that's typically what big institutions buy when they're buying them from bullion banks. They weigh about 27 pounds. Right now, each one of those 400-ounce good delivery bars is worth about right at $1 million. So you would need 10 of those good delivery bars. I mean, the treasurer could put it in his safe in his office if he didn't want to farm it out to, you know, a bullion vault somewhere. But we do have one in the state now, Class 3 vault, precious metals operator. They mint a sovereign legal tender coin for 20 foreign countries. They've got a Class 3 vault. It's guarded. You can go inspect it. You can do state audits anytime you want to, if that was what the treasurer, you know, chose to do. So anyway, that's I don't want to bloviate on here too much more, but I think it's a good move here. I would like to just close out here with one good quote from the second president of our United States, where he said, "There are two ways to conquer and enslave a nation. One is by the sword, and the other is by debt." So I ask for your favorable vote. Thank you.
Ready for the question? Senator Cold.
Thank you, Madam Chairman. Just a question. What's it going to cost to store this said gold? I don't know. And I would like to say that if the good senator from a very windy city that spoke here a little bit ago, if we would have got this done, we probably would have been quite a bit ahead with the value of said gold we were storing. But I just like to know what we're going to do with it. How do we monitor it? basically cost. I mean, I can't, are these folks doing it for nothing? That's my question. Thank you, Madam Chairman.
Senator Barlow?
Thank you, Madam Chairman. So I have two queries. One, is there anything that prevents our state treasurer from doing this now? And two, what is magical about the number, compelling a certain number? If it's so good, maybe it should be a much bigger number. Any comments on either of those? Thank you, Madam Chairman.
Senator Pappas, then Senator Schuler.
Thank you, Madam Chairman. You know, I was a no vote on this in committee because not that I don't think gold is a valuable commodity. I mean, holding gold is fine. If you're a personal person, holding it would be fine. I don't believe that the state should be holding something it's not going to make money on, okay? So compared to stocks and bonds, which we've been investing in with all of our income, our wealth, gold it's not income generating. You're going to stick it in a safe, it's not going to make any money for you. Yeah, maybe it'll go up a little bit in price over time. We did have testimony from the Treasurer's Office that our investments I forgot which indice they quoted, equities and fixed asset indices, that over the long term, not this last few years, we've had great prices jumps in gold, but over the long time, it's outperformed gold over 1,000%. That was the testimony. And I think last year, it was like 18% or 24%. That's good return. That's great if you're going to sell it, but it's just like your home and the problem that our taxpayers have. The price of their home went up, but they're not ready to sell it. They're not going to appreciate that income. They're not going to be able to get that income until they sell their home. Well, it's the same thing for us, I think, with gold. I don't know that the people in the state of Wyoming want us to hoard the gold when we can actually be taking the money that we would put in the gold and put it into investments where it can provide us returns. The gold will not provide us a return. It doesn't seem logical to me that we as a state should hold gold. And I think it's going to cost us, as someone mentioned, in storage fees and whatnot, and all the administrative costs of holding it. And if we only start with $10 million, what's that going to do for us? The good bringer of the bill said 10 million is not much. Yeah. You're right. Probably in our wealth, it is not much. But let me tell you, if the dollar goes crazy and plunges, the world economy is plunging. No one's going to buy our gold at that point. And what are they going to buy our gold with? I don't know. It just does not make sense to me to be sitting on gold when we can take our money and invest it and return and get the returns that we've been getting. Thank you, Madam Chair.
Senator Schuler, then Senator Smith.
Thank you, Madam Chairman. Just a quick question for the bringer of the bill. I looked at the fiscal note. It doesn't really say exactly if you'd have to hire more staff of the Treasurer's Office, or you talked a little bit about contract for services. So if we could just have a little bit of discussion on that. Thank you.
Senator Smith.
Madam Chair, I'm as conservative as this state is, I'm shocked that we don't have physical gold that we hold already. In terms of, I'm going to try not to sound like a gold commercial, but in 2001, you could have bought gold for $240 an ounce. Today, it costs you $2,700 to get an ounce. The dapper gentleman from the Rocket City right here, his suit is probably basically gold, an ounce of gold tracks with the value of a very nice suit. And we have a deflating dollar. So if you wanna, it's just a hedge. So I'm gonna guess that a very nice suit today would cost between $2,000 and $3,000. And you can go back 1,000 years, and you can always track where gold is. Gold does not lose its value. It's just a good hedge against a deflating dollar, an inflating dollar. And that's what we have. We have a currency that's devaluing, and we hope that that stops. But in the meantime, we need to diversify our assets.
Senator Anderson.
Madam Chairman, I agree with the previous speaker that said we need to invest this money and bring back that investment to support the state. Right now, we're 30% of our income is coming from our investments. And we've got people hired, very capable people, to invest that money to make us money. Now, none of them would say, put it in gold that does not return anything to you. Everybody knows that gold might go up or it might go down, but if it goes up, you don't make anything because you don't sell it. And I'm assuming we're not going to sell our stash, so we would not have any income coming off of that. So we can cut it into our investments now by about 10 million, and next year by 100 million. Pretty quick, we won't have any 30% of our income coming from our investments, nor will we need those investment brokers that we have that are doing a tremendous job of bringing money back. This is a great idea, but it does not return anything for the state of Wyoming. Thank you.
Senator French.
Thank you, Madam Chair. There was testimony in committee that the state has had different investments where they lost their shirt. They lost money. I don't think we're gonna lose a bunch of money on if we go with $10 million worth of gold. So, you can go up or down, but I'm in favor of this, I don't have the exact number. They didn't say how much, could be millions. I don't know how much the state has lost over the years on different investments.
Senator Salazar, and then Senator Crum.
Thank you, Mr. Chairman. Yeah, I've supported this idea from day one, and this has actually been a discussion we've had for a number of years. And but I think it's something, I personally feel it's something that we can put into our portfolio. Needless to say, I'm supportive of what the next 4 years is going to look like, but what happens after those 4 years? And Wyoming has always been prudent with regard to our investments, and so I'm in favor of this bill. Thank you.
All right, Senator Crum.
Just kind of an addition to my good friend from the land of rocks and springs. What's the insurance cost? I mean, we got to pay to hold it, then what are we going to do to insure it, to make sure that it doesn't if it gets stolen or something?
Senator Ide, would you like to answer some of these questions?
Yeah. Thank you, Madam Chair. Yeah, a lot of good questions. Some I agree with, some I don't, but I'll start with the first one from good senator from Rock Springs here on what does it cost to store. So if you go to, there's like in the region, there's Brinks Vault in Salt Lake City, there's another one in Boise, there's another one in Casper, and typically 25 basis points is what the storage cost looks. And that's what you pay for to fully insure it as well, too. And have armed guards there all day long, effectively. So 25 basis points is a number that we've looked at and talked to some industry experts on. It can vary depending on where you are and how much it is and those sorts of things. So I hope that answers that question there from the good senator from up north in Campbell County. The magic number of 10 million it was just looking for some kind of minimum amount that was meaningful to get things started. And, gold it's a low time preference investment. And the good senator from Cheyenne here, it doesn't earn yield, but it does in situations where it's counterintuitive effectively to when stocks and bonds go down, gold typically goes up. So it balances a portfolio out. So, the stock market and bond market doesn't always go straight up, and it kind of ebbs and flows with gold to correct that and maybe hedge against that volatility. So back to the good senator from Campbell County, the question on whether the treasurer can buy gold right now. My answer to that would be that he can buy gold right now, and he hasn't. And I'm not, this is just a minimum. I'm not trying to push anything on anybody, but just to get the plumbing in so we can get started and really look at how this could really augment our state sovereign wealth fund. So let me see if I can hit on another question here. The good senator from Cheyenne here, I appreciate his comments, but as far as the investment returns, I really don't want to get in there. This is more of an insurance policy. As the chairman of revenue said, you got to be careful because the first liar never stands a chance when you start talking returns on this stuff. So I don't really want to wade in there, but my colleague here, another one from Cheyenne, gold over the last 25 years, 2000, it was $250 an ounce, give or take. And now it's 10x that. So it has followed inflation, and it looks like inflation is really ramping up even more. And I think this is going to be a continued hedge. I mean, the interest on our debt, I've got another flyer. I didn't want to throw it all out there to you guys. Let me back up just a little bit. It took us 200 years to get the first $1 trillion in national debt. That was in 1980. 200 years. You know what we deficit spent just last year that we didn't bring in tax dollars? $1.8 trillion. So we almost did the same thing that it took 200 years to do in 6 months. And it doesn't look like, I'm all for this new administration and DOGE on their, efficiency stuff. I hope they can cut $2 trillion from the budget out there to try to get things balanced out. But CBO's numbers, if they can't, we're looking at another $24 trillion in debt. And this has been the hedge over time gold has against the monetary racketeers that I like to say. I mean, there's no way out. It's almost like checkmate. The interest on our debt just right now is almost $1 trillion. I've got this on another sheet. It's more than Social Security, or more than our defense budget. Just the interest on the debt, and that's on pretty low interest rates. So anyway, I'll quit there. Let's see what, senator from the southwestern part of the state, contract services, we don't really need any for that matter. If the treasurer wants to use one of the vaults in the Capitol, but more of the contract services is just to get things sort of understand it, help them. They'll get a bill or a study to the interim committee. It's just sort of those things, but there really isn't a whole lot of overhead on this purchase. Trying to think here, Senator French, what did you, I can't remember what Senator French. States lost money. Oh, yeah. So the one thing with gold is it is low time preference. You're not going to get these, big, huge gains, but over time, I mean, back when we were on a gold standard before we got the Federal Reserve in 1913, 1 ounce of gold was $20 an ounce. And, it is volatile. A lot of people talk about that. It goes up and down, but it always goes up and down as we print more money and deficit spend. So, we have had some bad investment. I think that the CIO has done a very good job. with his investments down there, but we lost $200 million in third world debt that we invested in. So this is a pretty small little hedge against a sovereign debt crisis, potentially. Thank you.
Thank you, Madam Chairman. I just want to give a couple comments. First, it is a fairly benign amount. It sets up policies and procedures should we choose to go that route later. It helps us get used to it. And I'd like to point out, according to our Constitution, paper money is unconstitutional. The only thing we should be exchanging in is coins. And it doesn't matter whether the coins are copper or gold or silver. So I think it's a good thing to explore and a good place to start, see what happens. If it becomes too cumbersome, we sell the $10 million worth of gold for $13 million and pick a fund we could put it in. Thank you, Madam Chairman.
Thank you, Madam Chairman. I'm not for or against gold. I think when you look at it as an investment instrument, there are times when it's appropriate to buy gold. There are times when it's appropriate to sell gold and buy into the stock market. And this is exactly the type of thing that financial managers do. And Madam Chairman, we have excellent financial managers as a state, and they are empowered to buy gold, to buy hedge funds, to buy tracking funds, to buy equities. We have a lot in statute, but they have requirements specifically about how they invest using the Prudent Investors Rule. And we have our IFC, our Investment Funds Committee, which is a group of experts. I mean, folks that really know what the best investment strategy in the near future is going to be, that we have the pleasure of having provide us with the recommendations that then go to the treasurer and become our investment strategy for the upcoming years. That's a great system. And that system, Madam Chairman, leads to a tremendous amount of revenue for the state. Now, our financial select committee is looking at ways to even improve that further to get a total return on investment. But that effectively is the objective. When we have investments, I think it's reasonable to say that what we want out of those investments is the highest return on the investment. We look to yield sometimes, we look to long-term return, but overall, we're responsible for the public's money, and it's incumbent upon us to invest it in the best way possible. Nothing precludes the IFC from recommending, and I'm sure they do from time to time. I haven't looked to see when, if, or how they provide recommendations related to precious metals. But at the end of the day, the recommendations they're providing are to give the highest return on investment to the state of Wyoming, with risk taken into account, with diversity taken into account. They do things right. Now, Madam Chairman, the concern I have is that the idea that instead of that approach where we have experts in investment trying to optimize the ROI for the state, we have instead legislation that basically says, this is the investment that I like. And this might be an investment that many of us like, and I understand that it is. Clearly from the testimony, this is a good investment. Others among us like different investments, and I can just imagine a circumstance where we come back and all of us want specific investments over the years, and we bring legislation, and we basically fundamentally break the system where we have experts advise us on how to invest in a diversified portfolio that leads to a maximum return on investment. About a third of our revenue at this point comes from the success story that is our investment portfolio. And while this is not a daunting amount of money, $10 million, I think it sets a bad precedent when we decide that we can outdo the experts that we employ that are looking at this objectively through a lifetime of experience as a consortium providing their best recommendations that are then invested in a diversified portfolio pursuant to the prudent investor rule, that we just get to the point where now it's every legislator's favorite investment. And I've got some too. I've got some investments that I think are great ideas as well. I just don't think we should go down the path. And again, you know, when you look at the history, and I pulled up a great website that'll give you the return on the S&P 500 versus the return on gold based on any date you start. And it was kind of fun just playing with it for a couple of minutes, Madam Chairman, because I could find dates where gold was way better than the S&P 500. And then I just shift the date a little bit, and then the S&P 500 massively outperforms the gold. Just exactly as we would all expect, right? It's good when it's good, and it's bad when it's bad. That's regrettably the way the market tends to work, and none of us seems to be expert in guessing that, or perhaps we wouldn't be here today. So I urge caution on this bill, and I appreciate the concern, I appreciate all the interest behind it, but the idea that we as a legislature start shifting our investment strategy, you know, this is one of those things that I don't think it's a path we should go down for the health of the public and for the health of our permanent funds. Thank you.
Ready for the question? Senator Cole, then Senator Ide.
Thank you, Madam Chairman. So if I do the 25 basis points, right, this is $25,000 a year. If it's a year, number one, from the good senator from the very windy city, I'd expect a better deal. So I don't know. It seems like a pretty good sum to park this product there, considering how little space it takes. So I guess I come down to it. I'm surprised it's that high of a cost. So I guess maybe there's better explanation, or maybe we can cut a better deal. I don't know, but we're going to be, you know, under certain circumstances, losing money here, and someone's going to be gaining money. And I applaud the people in an area to put a certain type of vault in of this quality, but it seems like we could do a little better with the cost of said storage. Thank you, Madam Chairman.
All right, Senator Ide, and then we'll go to the question.
Okay, I'll close this out here. Good senator from Ivory Tower, he's predominantly referring to this as an investment, and this is more of an insurance policy. That's kind of what gold is. Gold is kind of tries to do the opposite of what the market, you know, the great financial crisis, or when the money printing goes on. And, you know, all of the investments that we have that are earning us, they're all dollar denominated investments. And, you know, and I think even some of our pension stuff, they hold gold in an ETF. But this is about holding physical gold. Some of the true believers say, if you don't hold it, you don't own it. And so I want to just kind of convince everybody that we're not trying to beat the market. We're trying to hedge against the money printers. I mean, we've got inflation that is out of control, and it doesn't look like it's going to slow down anytime soon with another 24 trillion, you know, stacked on top of that. If you look at history, any fiat currency, any currency that's not backed, that hasn't been backed by gold, eventually goes to zero. Its intrinsic value to zero, because, you know, you go to Weimar Germany, 1920s, you know, there's a little commercial where a guy's wheeling his Reichmarks up in front of the pub to go in and get beer, and it's piled with Reichmarks in there. That's when they had hyperinflation in the 20s, and he comes back out to get his money to pay for the drink that he just bought, and the money's still there and the wheelbarrow's gone. So those are the kind of things that the currency eventually gets worthless as you continue to debase it constantly. So that I want just to remind you, this is more of a hedge. It's a small amount. Try to get the treasurer on board to figure out if this really augments our sovereign wealth fund. And, you know, the 25 basis points, you know, that sounds like a lot, but if gold goes up, you know, 10%, that's $1 million, and it only costs you $25,000 to get that 10% returns, or that $1 million. So anyway, keep it in perspective. But I think other states are doing it. We're the #1 sound money state in the country. Part of why the one in Casper moved here is because of our laws. They saw that act we passed in 2018, the Legal Tender Act. They looked all over the world. They could have gone anywhere. They moved their storage facility and their men here. We could, if we stay on the map and people see that we're the Switzerland of America, that might draw more economic development here too. I mean, he came here with no subsidies, no taxpayer subsidies. He didn't ask for anything locally, state. Those are the kind of businesses we want to attract, and he employs 50 employees there, just to give you a little backdrop of why this could be a good diversity for our economy in this state. So I'll finish there. Thank you for letting me talk on, and look for your favorable consideration.
Ready for the question? Senator Pappas.
Yes, I just want to remind everybody that it will not be a hedge against inflation unless you divest yourself of the gold at some time, right? If we just hold the gold, waiting for that bad day when the dollar is no longer good in this country, then we try to divest ourselves of the gold. Who's going to buy our gold, and with what fiat currency? I just don't see the rational thinking there. So remember, this will not, if we hold the gold, it will not produce income, because the intent is to hold it. Now, if you want to trade in gold, that's a different story. There's a lot of people out there that make money trading short and long on gold, right? I think that's true. I mean, that's how short-term trading is going on in this country, in crypto, in Forex, in gold, any precious metal. But you got to be trading it to make money in it. That's investing in gold. We're not investing in gold here. We're just putting it away for a rainy day, apparently. But I see that when it rains that bad and the dollar is no longer worth anything, I don't think our gold is going to be worth anything. It is a hedge against inflation, typically when our dollar becomes undervalued. But when our dollar goes away, if it ever goes away because of some collapse in world economy, I don't think gold is, I can't spread it on my bread like I do butter. So I just think there's a fallacy in the thinking that holding gold is gonna somehow help us in the long term if there's some kind of economic disaster. Thank you.
Senator Cooper. And just a fun stat, we are on bill number 3, and I've got 9 more in my pile up here. Senator Cooper.
Thank you, Madam Chairman. Neither for nor against here, just a little quick information. Over the last 45 years, the average rate of inflation all across there is 2.83%. The price of gold has risen by 3% per year over that same time period. So it's matched inflation, no gain, no loss. It's just staying with inflation.
Further discussion on the bill? Further discussion? Senator Hicks. Hold on, Senator Hicks.
Mr. Chairman, Mike. So I'll just to interject a little bit when we talk about why government shouldn't own gold, and I'm always bring back as the largest gold holder in the world is the United States of America. And since 1976, when we went off the silver standard, we have held 8.1 metric tons of gold since 1976. Central governments around the world hold giant, enormous stores of gold. So along with those, number 2 is Germany holds about 3.4 million metric tons. The IMF, the International Monetary Fund, Italy, Russia, and China. The largest purchaser of gold in the last decade has been China. Central governments around the world hold gold, and they're still purchasing gold. And so there's a reason for that. And the reason is because it is an insurance policy. We'd be much better off is just to get rid of that 8.1, which is somewhere into, I can't remember, it's $400 or $500 billion if we sold that gold today, and we just have the federal government invest that in the S&P, and we'd be a lot better off into the future. There's a reason we hold gold. So neither on and for, but when every other government entity around the world is either buying or holding gold, there's a reason for it.
Further discussion, Senate File 96, further discussion, seeing none. Are you ready for the question? All those in favor of Chairman McEwen's motion, when the Committee of the Whole rises to report, it do so with the favorable recommendation of Senate File 96, please say aye. Aye. Those opposed, no. Senate File 96 has passed Committee of the Whole. Next bill for our consideration is Senate File 65. Reading clerk.
Senate File 65, Data Privacy Government Entities, an act relating to the administration of the government, sponsored by the Blockchain Committee, was referred to Committee Number 9, which returned a committee recommendation that it do pass amended. Ayes Senators Anderson, Cooper, Jones, Nethercott, and Rothfuss. Senator Anderson, Chairman.
You have heard the reading of the bill. What is your pleasure? Senator Anderson.
Madam Chairman, I move that when the Committee of the Whole rises to report, it do so with the recommendation of that Senate File, whatever one we're on.
65.
65 do pass. Thank you. And to talk about this good little bill is Senator Rothfuss.
Senator Rothfuss.
Thank you, Madam Chairman. Madam Chairman, I'm going to walk through the bill and then I'll get to the amendments. Madam Chairman, Senate File 65, Data Privacy Government Entities, is the work of the Blockchain Select Committee during the interim. Madam Chairman, this is a bit of a challenging bill, honestly, to work through because there are a lot of issues to resolve, but it's inspired by some circumstances in recent years where there were data concerns for some government entities, one in particular where in the northeastern part of the state, some data was purchased by a government entity, and that caused some concern because it was purchased about residents in the state of Wyoming. That caused a great deal of concern because effectively that then becomes data of the government, potentially public data, and the purchasing was what caused a lot of consternation. So based on concerns that the government was effectively collecting and maintaining without check too much information about the citizens of the state, we worked on this legislation to try and provide some limitations, and we provide as much flexibility as we can, but we make sure that government entities all have a plan about how to use the data and all have a justification about the data they keep, as well as a specific interest in not buying, selling, or transferring that data without permission of an elected entity. So to run through the legislation quickly, on page 2 we see some definitions. De-identified data is basically data that you can't link to an individual natural person. A government entity, for the purposes of this legislation, includes all of the government instrumentalities, agencies, subdivisions of the state, but shall not include the judicial branch of government or any law enforcement agency in Wyoming, which already have laws that we thought were reasonably robust in terms of how they handle their data. Identified or identifiable natural person means a specific person through an identification number, location, online identifier, etc. Law enforcement agency is defined to facilitate the previous definition. Personal data, this is important, means information that is linked or reasonably linkable to an identified or identifiable natural person or personal digital identity, and does not include de-identified data, because the personal data is what we're going to focus on through this legislation. Personal digital identity refers back to elsewhere in statute. And then the meat of the bill, Madam Chairman, on page 4, gets to the limitations on personal data by government entities. It indicates, and this is really the heart of things, no government entity shall purchase, sell, trade, or transfer personal data without the express written consent of the natural person, except as otherwise expressly provided by law, and accept that. Romanet 1, a government entity may transfer personal data to another government entity, such that as long as that entity confers with the rest of this legislation. Romanet 2, a government entity may petition the elected governing person or body with direct authority over the entity for an exception to this language, and that written permission would last for up to 2 years. So this is a general exception where the legislation does not necessarily accommodate for real-world circumstances, and we've heard some that might be challenges. We recognize that others might not be foreseen. So an elected authority is able to allow for an exception to A, but it has to go to that elected authority. You can't just have an appointee or somebody within that agency making the decision. The elected body in charge would have to provide permission. So you could imagine our governor would provide permission for our state agencies. County commissioners might provide exceptions, but those exceptions would have to be provided in writing and last for up to 2 more years, although they could continue to be continued through time. Madam Chairman, on page 5, one other additional exception indicates that nothing in this subsection shall be construed to prohibit the transfer of personal data that is otherwise compliant with HIPAA and FERPA. B paragraph is a transparency right that any Wyoming resident may request a copy of their personal data from any government entity maintaining it, and they shall receive it subject potentially to a charge, but that's consistent with the de minimis charge going with the Public Records Act. The C paragraph, a Wyoming resident who objects to the accuracy, completeness, pertinence, timeliness, relevance, retention, dissemination, or denial of access to the resident's own personal data that is maintained may file an objection through the government entity, and the government entity would have to respond within 60 days. Following that response on page 6, they'd have to investigate the validity of the objection, and if the objection is found to be meritorious, they would alter the contents or otherwise comply based on the objection. Romanet 3 indicates if there's a lack of merit, they would provide the resident with an opportunity to have a statement reflecting their resident's views. And Romanet 4, they would notify the resident in writing of any decision. A very important part of this is paragraph D. To the extent that a provision of this article conflicts with another provision of state or federal law, the other provision shall control. This is important, and this applies fairly often. A lot of times we do a notwithstanding. In this case, this legislation defers to any other explicit law that is to the contrary. So if there is a law in place that talks about data disclosure or selling or buying data that's explicit in statute, that will always govern over this. And there are cases where that comes into play, a lot of times with federal law, but ensuring that if conflicts occur, we defer to the other existing statute that is more specific. Section 2, another statute section that's created, gets to personal data collection and retention by government entities. You see in the A provision, in addition to the policies above, each government entity that collects or retains personal data shall adopt, enforce, and maintain a policy regarding the collection, access, retention, security, and use of that personal data consistent with state and federal law. It doesn't provide any details about what that policy is, realistically, other than otherwise complying with this. Very general, but it's a desire that every government entity actually have a policy about the personal data that's being collected. In addition, the B paragraph indicates, Madam Chairman, that no government entity shall collect or maintain more personal data than is reasonably necessary to perform their functions. So in other words, if you don't need the data, you don't get to collect the data, and you should be able to justify that. The C paragraph, no government entity shall maintain personal data for longer than 3 years without an express written policy identifying the extended retention period and providing a reasonable justification for the extended retention period. So this gets to collection and retention. We know that the government collects a tremendous amount of information, and then they seem to keep it forever. This says that they have to have a reason to keep it for longer than 3 years, and they have to write that reason down. Not an onerous burden, it doesn't preclude them from doing it, but it basically says justify your retention if it's longer than 3 years. And as a further discussion, you see at the bottom of page 7 onto 8, statutory retention requirements provided for in Wyoming statutes listed constitute a reasonable justification. That's the state archive legislation where there are archival policies that govern certain records where there might be a requirement for permanent records or otherwise. Madam Chairman, Section 3, not later than January 1st, 2026, the State Chief Information Officer, in consultation with the state archivist, will develop sample policies for all of our political instrumentalities. And then we see in Section 4, this goes effective for counties, cities, or towns on July 1st, 2027, and each political subdivision of the state otherwise on July 1st, 2028, so there's plenty of time. They have to adopt those policies. Madam Chairman, then there's a split effective date based on the discussion that we previously had. And with that, Madam Chairman, I'd like to go to the amendments. I'd like to ask that Standing Committee Amendment number 1 be read in at this time.
Senate File 65, Standing Committee Amendment number 1, page 4 after line 12, insert.
Madam Chairman, I move Standing Committee Amendment number 1 to Senate File 65. Ask the body's favorable consideration. Madam Chairman, there was some concern about the idea of transferring personal data being incorporated by third-party use, and that there would be a preclusion from agencies or instrumentalities using third parties to do their business, which happens all the time, and that that might constitute a transfer. So this Romanet 2 language provides that that type of engagement is not a transfer, but that the government entity, when it's using a third party, has to ensure, as they contract for services, that all of the requirements of this act are met, and that that non-governmental entity shall not maintain, sell, transfer, process, or otherwise use it without meeting the terms of this legislation otherwise. So with that, I'd be happy to answer any questions on Standing Committee Amendment number 1, and if there are none, I'd call for the question on the Standing Committee Amendment.
Ready for the question? All those in favor of Senator Rothfuss's motion to adopt the Standing Committee Amendment 1 to Senate File 65, please say aye.
Aye.
Opposed, no. Standing Committee Amendment number 1 to Senate File 65 has passed. We are back on the bill.
Madam Chairman, I'd ask that Committee of the Whole Amendment number 1 be read in at this time.
Senate File 65, Committee of the Whole Amendment number 1, page 5, line 2 after.
Madam Chairman, we received some concerns from our health sector, specifically about the language related to HIPAA and compliance with provisions of the statute.
Could you move that, please?
I certainly can. I move Standing Committee Amendment, Committee of the Whole Amendment number 1 to Senate File 65. Ask for favorable consideration. So with regard to HIPAA, HIPAA was discussed in the first part, but not the second part explicitly of the bill, with page 7, paragraphs A, B, and C. The desire by our healthcare community that would be potentially affected by this, where they have government entities overseeing it, was to ensure clarity that compliance with HIPAA would meet A, B, and C, which is reasonable. If you're complying with HIPAA, you would be meeting paragraphs A, B, and C, because it is an express written policy that meets all of these objectives. We also included FERPA, which is the Family Education Rights and Privacy Act. It's similar, but it relates to students. And so this legislation addresses that concern to provide clarity so that we don't have to have redundancy for our hospitals and for other entities, so to try and address that concern. I'd be happy to answer any questions on this Committee of the Whole Amendment at this time.
All those in favor of Senator Rothfuss's motion to adopt Committee of the Whole Amendment 1 to Senate File 65, please say aye.
Aye.
Opposed, no. We're back on the bill.
Madam Chairman, I know that the enthusiasm meter is a little bit low right now, but I'm enthused to answer any questions or have any discussion or debate on this good little bill that we spent a good bit of time during the interim working on. I think it will protect privacy of individuals around the state, and we worked hard to address the specific concerns of all the agencies and entities that came forward. We did have support from our association that represents our municipalities around the state and other entities, and I feel like we're in a pretty good place. If anybody does hear any specific examples that we're not meeting I would ask that everybody let me know, because I want to make sure that this is meeting all of the interests. And you can see the size of this. It might have some unforeseen consequences, but we did include a couple of provisions to ensure that we have a check on those unforeseen consequences. We've got a couple of different outlet valves available, Madam Chairman. Happy to discuss.
Question? Oh, Senator Hutchings.
Thank you, Madam Chair. Senator, just a quick question on page 7, line 20. What's going on in the 3 years that maybe they can do in 1 or 2? Thank you.
Anything else? Senator Cole.
Thank you, Madam Chairman. Just a question on the fiscal note. It's noted that they can be substantial impacts, and I guess maybe I could hear more about that. Thank you, Madam Chair.
Senator Rothfuss.
Madam Chairman, to address the 3 years at the bottom of page 7, we had some discussion about how long that default should be in the absence of policy justification otherwise, and ended up coming up with 3 years, honestly. Shorter than that, there's not even enough time sometimes to process it, but that does seem like enough time that any entity should be able to really have a reason to have it longer than 3 years. It was kind of a compromise timeline that we arrived at. There's nothing magical about it. I think the archives standard tends to be around 5 years or 10 years, and that comes into play fairly frequently, but we had discussions with the archives about it. Madam Chairman, on the fiscal note, to the good senator from the southwestern part of the state, obviously there's no appropriation, but one of the concerns that was raised by a few different agencies, some of our colleges and universities, suggested that it would cost some administrative time, because they would have to put forward policies to comply with this, and depending on the size of the entity, those policies might be challenging. Madam Chairman, in our discussions during the interim, it kind of came down to, at that point, a little bit of concern. If you don't already have these policies, you really need to have these policies. It's important that you protect the data of the people of the state of Wyoming. So we didn't provide any fiscal note, but we did ensure that ETS would take the opportunity to provide some samples. ETS did not have any objection or provide any concern themselves for additional time that it would take to do that. So while we understand that there is an administrative challenge associated with this for some entities, we've given a few years before this fully goes into effect, and then we provide those sample templates. We didn't hear any requests for appropriation or additional funds. We just saw that some agencies were a little more concerned with how much work it was going to be administratively than others.
Ready for the question? All those in favor of Senator Anderson's motion that when the committee of the whole rise to report that it do so with a favorable recommendation of Senate File 65, say aye. Aye. Opposed, no. Senate File 65 has passed committee of the whole. The next bill for our consideration is Senate File 5.
Senate File 5, School District Vehicles Flashing Lights Authorized, an act relating to motor vehicles, sponsored by Senator Cooper. Was referred to Committee Number 8, which returned to committee recommendation that it do pass. Ayes, Senators Anderson, Brennan, Cooper, Cole, and Pappas. Senator Pappas, Chairman.
You have heard the reading of the bill. What is your pleasure, Senator Pappas?
Thank you, Madam Chairman. I move that when the Committee of the Whole rises to report that it do so with a favorable recommendation on Senate File 5, and for an school district vehicles flashing lights authorized, and for an explanation of this fine bill, I turn it over to Senator Cooper.
Senator Cooper.
Thank you, Madam Chairman. It's a pretty high-tech bill here, folks. Brought to us by a school district up in the far northwest county. Very small school district that uses Suburbans for school buses. A lot of the smaller districts do that. Again, we used to do it years ago, and we ran into a deal a few years ago where the feds decided that we all had to have a big yellow school bus. We got some of these routes that run 20, 30, 40 miles up the creek with 2 or 3 kids on them. A big bus doesn't work. What they've ran into there is a safety issue. When they've got the kids on a suburban type vehicle and going down the highway, getting ready to make a left turn, they're running into, folks trying to pass them, different things. So all they want to do is put a yellow flashing light, like you'd see on top of a utility vehicle or maybe a YDOT truck. Put that yellow flashing light on top of their Suburban to just draw a little more attention to it for the safety of the kids on board. And this bill says exactly that, page 2, line 5. Vehicles owned, leased, or registered to public school districts that are not a school bus and that are used to transport children to or from school or in connection with school activities. So these districts use these buses not only to bus the kids, but maybe they'll take 2 or 3 kids to an activity 100 miles down the road. They just want to be able to light that bus up, that Suburban up, and make sure that people see it. They're usually marked as a school bus, but they're not allowed to have the school bus flashing lights. And under current law, they're not allowed to have a yellow light on top. Thank you.
You ready for the question? Senator French.
Almost. Thank you, Madam Chairman. I stand in support of this. This is a good idea, Senator Cooper come with. This will help make it safer when they're transporting our beloved children around. Thank you.
Thank you. Senator Rothfuss.
Thank you, Madam Chairman. On for the bill, I do have a question, though. We passed a number of years ago some legislation that related to flybys of school buses, and that basically meant you can't be passing the school bus when it's in a stop position. I was wondering if you looked at those statutes to make sure that there was clarity. I assume that these vehicles, that statute wouldn't apply to, but I honestly don't remember how we phrased the language, Madam Chairman, and I think it would be confusing if it were treated as a school bus with regard to that statute. I was curious if there was any conversation about that. I can try and dig into the statute if there was no conversation.
Senator Ide.
Yeah, thank you, Madam Chair. I'm in favor of this bill too. This is a good one. It doesn't expand government either. So I always like that anytime I see that in a bill. So I'm in favor of the good senator from the 5 counties bill.
Senator Cooper, you want to answer? Oh, Senator Pearson.
Okay, being a driver, I think that this is a good idea. I'm not sure that the stop arm law that you're talking about would apply to this. Are these lights being installed to make the vehicle more visible? We're not saying that other vehicles cannot pass this vehicle on the highway, right? It's just to make them more visible? That would be my question. Thank you.
Senator Cooper.
Thank you, Madam Chairman. So no, this isn't about the flashing lights where you would normally have to stop for the school bus. This is simply to make that Suburban more visible on the highway. Up in that area, they go up Highway 120 and make a left-hand turn off onto a county road or a lane. That's where they have the issues. We're not talking about getting a fine for passing the school bus, anything like that. This is simply, all they want to do is put a flashing yellow light on top of that Suburban and do it legally. Thank you.
You ready for the question? All those in favor of Senator Pappas's motion that when the committee of the whole rises to report that it do so with a favorable recommendation of Senate File 5, please say aye. Those opposed, no. Senate File 5 has passed committee of the whole. The next bill for our consideration is Senate File 86.
Senate File 86, Alternative Teaching Certificate, Act relating to the certification of teachers, sponsored by Senator Larson, was referred to Committee Number 4, which returned a committee recommendation that it do pass amended. Ayes Senators Brennan, Olson, Rothfuss, Schuler, and Scott. Senator Schuler, Chairman.
You have heard the reading of the bill. What is your pleasure, Senator Schuler?
Thank you, Madam Chairman. I move that when the Committee of the Whole rises to report it, do so with the recommendation that Senate File 86 do pass. There is a standing committee amendment. If you could have that read in, please.
Senate File 86, Standing Committee Amendment Number 1, page 1, line 9, after.
And I will turn the time over to the good senator that brought this bill. Thank you.
Senator Larson.
Madam Chairwoman, thank you, and thank you, Madam Chairwoman, for the education. This is a bill that I had brought a couple years ago, and it went through pretty good over on this side, and we got over to the other side and had a little issue in the committee, and we were told that the board that controls teacher certification in the state could work on this. They could figure out a way that these companies that do alternative ways of getting a certification, they said we can figure that out. We can get it so it'll work. Well, they've had 2 years and they haven't succeeded at that. They've added some stuff in there that doesn't work for these alternative routes for getting certification. One of them is that they will require them to be accredited, and if you're accredited, you almost have to be tied to a university. And so that's a big obstacle that we need to take care of. I don't know if we'll get it done in this bill, but I kind of think we should. But I'll go through the bill real quick. No, there was an amendment. I would ask it that, I guess it was ready.
It's been read in.
So I move, oh my word. Amendment, wow. How can
Standing committee.
You lose your focus, don't you? Standing Committee Amendment Number 1 to Senate File 86. It's funny how you lose your mind up here. But anyway, I move that. And I would like to incorporate it as I kind of go through the bill. They pretty much took a lot of it out, but they made it really a lot better. But anyway, this amends some statutes. The first thing the amendment does is it inserts A on line 9, deletes on line 10 and E, and replaces subparagraphs with subparagraph. Okay, and then we go to 21.2.802, and this is the powers and duties for teacher certification that the board must kind of follow, and that should follow. And then on A, it says the board shall promulgate rules and regulations. And then we go to little I, 2I, and go to the new D. And on that section, on line 11, they deleted after program the remaining part of that line, and then they deleted all the way through the rest. Oh no, we did, then they deleted all the rest of page 2, and pretty much all of page 3, 1 through line 7, 1 through 7. But the amendment they put in, I'm gonna go ahead and read it. I think it makes it a lot better. So on line 8, it says alternative certification of teachers that requires this is what it'll be required. The board shall promulgate these rules. Alternative certification for teachers that requires a baccalaureate degree from an accredited college or university and successful completion of an alternative certification program. And then we go to the new amendment. Approved by the board that at a minimum requires passage of a subject area examination, pedagogy examination, also United States Constitution examination, Wyoming Constitution examination, and then is issuance of this alternative certification shall be limited to the subject areas and grade levels successfully completed by that applicant. I think it's a good amendment, and I would ask for your aye vote, and I can talk, if you have questions, I'll go through them, but I would recommend that you vote aye on the amendment.
You ready for the question? All those in favor of Senator Schuler's motion to adopt Standing Committee Amendment Number 1 to Senate File 86, please say aye. Opposed, no. All right, we're back on the bill. Any questions on the bill?
I'm gonna wait and see if there are.
All right. All those in favor of Senator Schuler's motion that when the committee of the whole rise to report, that it do so with a favorable recommendation of Senate File 86, say aye. Aye. Those opposed, no. Senate File 86 is passed committee of the whole. The next bill for our consideration is Senate File 168.
Senate File 168, Budget Reserve Account Repeal, an act relating to public funds sponsored by Senator Hicks, was referred to Committee Number 2, which returned a committee recommendation that it do pass. Ayes, Senators Driscoll, Garud, Larson, Salazar, and Smith. Senator Salazar, Chairman.
What is your pleasure, Senator Salazar?
Madam Chairman, I move that when the Committee of the Whole rises to report, it do so with the recommendation that Senate File 168 do pass, and I will pass this on to Senator Hicks.
Senator Hicks.
Madam Chairman and members of the body, you have a handout on your desk because this is going to be the best way to explain what this bill does. It should have, so what I'll ask you to do is pull that out. It's got Senate File, whatever the Senate File is, 168 on there. I'm just going to walk you through what the bill does and why we're doing it, and then a quick breeze through the bill itself. But to understand what this does, it's really easy. A picture's worth 1,000 words, folks. And so if you can pick that up. So what it does is, and if that's not on your desk, just grab your goldenrod if that's handy too. So it's a 2-page, so we're going to start out, yeah, if you look over there with my colleague from the Ivory Towers, it's kind of a darker photocopy. Yep. Everybody got that? This is the absolute easiest way to understand what this bill does, and then I'll talk a little bit. So when you take this is a copy of your goldenrod. And now that we've looked at this a number of times for the last couple weeks, you're starting to understand the level of complexity with all the different accounts we have on there. So what the bill does is that if you look at that second one down that's crossed out, which is called the budget reserve account, that's what the bill does. It repeals the budget reserve account. Why would we want to repeal the budget reserve account? So flip to that next page. This is right out of your fiscal data books. You all had those on your desk when you come in. This is a description of what the budget reserve account does. And so I'm just going to read the first. This account was originally created as an intermediate savings account or a rainy day fund. The BRA currently, budget reserve account, currently serves as a secondary checking account against the general fund draws upon the general operations of government. So we have 2 checking accounts. And the question is why do we have 2 checking accounts? Well, it wasn't originally supposed to be a checking account. It was supposed to be a rainy day account. We now have a rainy day account called the Legislative Stabilization Reserve Account. So all the bill does is consolidate or repeal the budget reserve account. All those funds now flow into the general fund. Why do we do that? Because it's transparent. We don't need 2 checking accounts, we need 1. So the only thing it does is it takes the budget reserve account, gets rid of it, transfers all those funds. The funds that go into the budget reserve account are from federal mineral royalties and severance taxes. It just moves those, and that flow now goes into the general fund. Now, I'll just walk you through the bill real quick. Most of this goes in and it repeals the budget reserve account. It provides a transfer for those funds that are currently in there or obligated in there that may revert back to the budget reserve account. Those now flow to the general fund. And it just makes some conforming amendments, and then it repeats some obsolete language, and then it just requires a report back as to when all of these funds were transferred. It's effective starting on the new biennial fiscal year. Those transfers would occur 2026 on July 1st. You'll come in here and you're going to pick up your goldenrod, and it's going to say general fund. No bar budget or reserve account. This is just trying to add some simplicity and transparency to our budgeting system so you've got one checking account. I'll just walk you really quick through the bill. Section 1 deals with just a lot of, what you're going to see in this is everywhere in the green books that you see budget reserve account. That's basically what it does, is go through every section, every title that it references budget reserve account, and it just strikes that language out and then says those funds are going to be directed towards the general fund. So you just walk you through there real quick. You get over on page 2, we strike out budget reserve account. You get into page 3, just brings in some of the existing language, and if you go over and you follow that down to page 4, line 6, gets rid of budget reserve account and says general fund. Same thing on the bottom of the page, says those appropriated funds will be maintained now as reserves within the general fund and not the budget reserve account. New language down on the bottom of page 5. This is just consistent with where the unappropriated funds currently would flow with the budget reserve account. Now they're going to flow into the general fund if there is any unappropriated funds. Turn over to page 6. These are the unappropriated funds in the budget reserve account, if and when that ever happens, which I'm not aware of at any recent time. Those would flow into the general fund. So you go all the way through the bill, it strikes out general fund, and I just want to bring this to everybody's attention based on the last discussion we had on my colleague from Park County's bill. When you go to page 9, it talks about separating these accounts. And 70-30, that's the exact language in the budget reserve account now. It just brings that in to the general fund. Doesn't mean it's going to happen. So it says the state budget may include recommendations for additional agencies. And then it gets down, if you read through that section, it talks about 30% to the population of the counties, 70% to cities, towns. That's the existing language in the budget reserve account. It's my consultation with our chief fiscal officer, that's never happened. I would be more than happy to entertain a second reading amendment to get rid of that language, but it is the existing language in the budget reserve account just transferred in that says that same language now could be used for the general fund. So all that's just a transfer of the existing language. The rest of the bill just gets rid of all those references to budget reserve account. You get all the way back to the end, section 4. This becomes effective July 1st. 2026. I'd stand for any questions, just trying to provide simplicity, clarity, and a little more transparency as to where the funds come from and how they're going to be spent. So I'd stand for any questions.
Senator Barlow.
Oh.
Question? All right. All those in favor of Senator Salazar's motion that when the committee of the whole rise to report that it do so with a favorable recommendation of Senate File 186, say aye. Aye. Opposed, no? Oh, whoops. Let me do that again. I transposed numbers up here. How about all of those in favor of Senator Salazar's motion that when committee of the whole rises to report that it do so with a favorable recommendation of Senate File 168, say aye. Aye. Opposed, no? Senate File 168 has passed committee of the whole. The next bill for our consideration is Senate File 106.
Senate File 106 motor vehicle dealer and manufacturer warranty rates, an act relating to motor vehicles sponsored by Senator Barlow, was referred to committee number 8, which turned to committee recommendation that it do pass. Ayes, Senators Anderson, Brennan, Cooper, and Pappas. No, Senator Cole. Senator Pappas, Chairman.
You have heard the reading of the bill. What is your pleasure, Senator Pappas?
Thank you, Madam Chairman. I move that when the Committee of the Whole rises to report, that it do so with favorable recommendation on Senate File 106, motor vehicle dealer manufacturer warranty rates. And for an explanation of this bill, I ask you to call on Senator Barlow.
Thank you, Madam Chairman. Thank you, members of the body. Before you, Senate File 106 is I think what we'd call it is a product of a lot of work between motor vehicle dealers and manufacturers. It was negotiated over the last year plus. And we are the last state not to have something in place that kind of balances this relationship that we have in our franchise laws in the state of Wyoming. Chapter 16 of Title 31 is the franchise laws of Wyoming. And this is a very small part of it, but a very important part of it. So, Madam Chairman, I'll just kind of give you an overview looking at the short title, and then I'll walk you through the bill. So what this bill does is have a process in place to establish, this is right out of the short title, establish our labor rates and retail markup rates for warranty repairs. These are repairs that the dealership does on behalf of a customer, but that the manufacturer is paying for. So the company that is paying for it, it's not the consumer paying for it, it's the company that manufactured the vehicle. And right now in statute, we have kind of a interesting circumstance, and we'll just go to page 2 of the bill. And what this bill does is kind of clarify it actually lays out a process for doing this, and it removes a cap that is in current statute about parts makeup. So if you go to page 2 of the bill, you'll say a lot of existing language, but then on line 14, you'll say for the parts, it says a 30% markup. That's just what state statute says about the markup for the dealerships when they're doing warranty work. Well, that's not what's actually happening on their non-warranty side, the free market side. So the state in this instance has stepped in there. If you go up a little above, when we talk about the hourly labor rates, we say, well, you can negotiate that, but we actually don't have a standard about how that is negotiated. So the rest of this bill, Madam Chairman, is about the process of negotiating both of those rates, the markup for your retail parts and the hourly labor rates. And both of those things, one, you can come to it by mutual agreement. Just say, what do you think about this? What do you think about this? They come to it, the parties come to it. If they can't come to agreement, then you start on the bottom of page 3, and you go through the remainder of the bill, and that's the process that's laid out what will be laid out in statute if this is approved, that talks about how they share information, how they consider information, how they negotiate, and if they can't negotiate it, they mediate it. If they can't mediate, they go to the courts. And so this process, like I say, Madam Chairman, is laid out in all kinds of specificity. I'll highlight a few things as I go through it. One, a new dealer can only ask for this change once a year. They can't change it every 6 months or every 2 weeks or whatever. Once a year. Once they've set a rate, it's in place for a year. There are things that are excluded from how this is done. Certain activities and certain maintenance that they will not consider if they have to go through this process. That's on page 6 into page 7. And then we have more process. And then the manufacturer has the rights, the ability to say, no, what you're doing is not material. What you're providing us is not complete, it's inaccurate, or it's unreasonable. And then there's a process to go through that, and that's where the mediation in the court comes in. So, Madam Chairman, I can see there's a lot of people really interested in warranty work in the automobile industry. So I'll be glad to stand for questions. You will hear concerns, and I want to acknowledge that why do we even have this? Why do we even have franchise law in Wyoming? And franchise law in the automobile industry, where the automobile industry is throughout the United States by state law. And because if it wasn't, it might be by federal law. We don't want that. But more importantly, this balances the relationship between very large companies, multinational, international companies, and our businesses, our hometown businesses. Those folks that are, own those dealerships, some of them have multiple dealerships, but a lot of them are family businesses, been in business for many, many years, and there has to be some leveling of the field, what this does in that relationship. So anyway, Madam Chairman, I'd stand for any questions and ask for your favorable consideration of Senate File 106.
Question, Senator Hutchings.
Thank you, Madam Chair. Just a quick, for instance, from the bringer, like maybe small business versus, I don't want to really say, maybe, how to put it, a dealership that has maybe little stars in their symbols. Can you kind of tell me how that comparison works with the bill, if I'm asking correctly? Does that make sense to you? A dealership, yeah, I think you understand.
Madam Chairman, I'm trying to come up with what has stars, and about all I can see is stars right now. But anyway, thank you, Madam Chairman. So the relationship, first of all, as you know, dealerships actually have territories. They have an area that they serve. And so part of that is, you could argue, well, there's some protection in that. Well, yes, there is, because there's only so much the manufacturers want to have. They don't want to completely, decimate the market. They want really good dealerships in areas, and they want to work with them so they have the best. What this bill does is it allows us to compete with those competitors that are out of state, those dealerships across the state lines, and improve the reimbursement rates potentially for warranty work. And the market sets the market, the non-warranty work sets the rates, and then they get to have the advantage of getting reimbursed more appropriately at the market rates by the manufacturers. And I'm sorry, I will come over there and I will find out what stars you're looking at, because I don't know what stars they are. Sorry, Madam Chairman.
Senator Crum.
Madam Chairman, I speak in favor of the bill. I've talked to our local car dealers in our area, and they're all in favor of this bill.
Are we ready for the question? Senator Smith.
Madam Chair, I'd just like to reiterate that this is a good bill, and it cleans up a lot for our car dealers, and I encourage everybody to vote for it.
All right. All those in favor of Senator Pappas' motion that when committee of the whole rise to report that it do so with a favorable recommendation of Senate File 106, say aye. Aye. Those opposed, no. All right, Senate File 106 has passed committee of the whole. Majority Floor Leader. Oh, sorry.
I think there's a senator trying to get more bills passed in this late hour. However, Madam Chairman, I move that the Committee of the Whole rise and report.
You have heard the motion. All those in favor say aye. Aye. All opposed, no?
Motion carried. Committee of the Whole report.
Mr. President, your Committee of the Whole, having had under considerations bills on general file, begs leave to report as follows. Senate File 71, do pass. Senate File 91, do pass amended. Senate File 96, do pass amended. Senate File 65, do pass amended. Senate File 5, do pass. Senate File 86, do pass amended. Senate File 168, do pass. Senate File 106, do pass. Senator Brennan, Chairman.
Randy must be hungry because that was fast. Senator Brennan.
Mr. President, I move the adoption of the Committee of the Whole report.
You've heard the motion. All in favor say aye. Aye. All opposed, no.
No.
Committee of the Whole report has been adopted. Oh, boy. we have any announcements or messages? Okay, standing committee reports.
Mr. President, the following reports are dated January 29, 2025. Committee number 3, Revenue, to whom is referred Senate File 153, Residential Real Property Taxable Value, respectfully reports same to the Senate with a recommendation that it do pass amended. Ayes Senators Case, French, Ide, McEwen, and Pappas. Senator McEwen, Chairman. Your committee number 3, Revenue, to whom is referred Senate File 150, For-Profit Trade Schools Property Tax Exemption. Respectfully report same back to the Senate with a recommendation that it do pass amended. Ayes Senators French, Ide, and McEwen. No, Senator Case and Pappas. Senator McEwen, Chairman. Your committee number 3, Revenue, to whom is referred Senate File 85, Constitutional Enforcement of Localities, respectfully report same back to the Senate with a recommendation that it do pass amended. Ayes Senators French, Ide, and McEwen. No, Senators Case and Pappas. Senator McEwen, Chairman.
Thank you. Messages from the House?
From the House of Representatives, Mr. President, the following report is dated January 29, 2025. Message number 147, House Bill number 199, Wyoming Freedom Scholarship Act, passed the House on third reading in an amended form. Ayes 39, noes 21, excused 2. Message number 146, dated January 28, 2025. Mr. President, House Bill 10, Limited Mining Operations Amendments, adopted the Committee of the Whole report, failing House Bill number 10, Limited Mining Operations Amendments. Ayes 17, noes 39, excused 5. The bill has been indefinitely postponed. Sincerely, Katie Talbot, House Chief Clerk.
All right, thank you. Madam Majority Floor Leader, that clears the desk.
Mr. President, I move that we stand recessed until 10 a.m., January 30th, 2025.
Adjourned or recess?
What did I say? People were.
You said recess.
Did I say recess?
Let's adjourn, madam.
Mr. President, I move that we stand adjourned until 10 a.m., Thursday, January 30th, 2025.
All right, committee announcements. Senator Landon.
Mr. President, your Travel, Recreation, and Wildlife and Cultural Resources Committee will meet tomorrow morning, 8 a.m. in W4 downstairs. That's the Wind River Room. And we'll take up Senate File 139, Trapping Requirements, Licenses, Seasons, and Setbacks. Senate File 140, Trapping Education Requirements, and Senate File 149, Wildlife Conservation License Plates Amendments.
Thank you, sir. Senator Pappas.
Thank you, Mr. President. Your committee number 8, Transportation, Highways, and Military Affairs Committee will meet Tuesday, tomorrow morning, January 30th at 8 a.m. in room W002 and online. We will continue with a bill that came up last week, Senate File 119, expedited professional licensure for military members, Senate Joint Resolution 007, NCSL 50th anniversary, and Senate File 141, United States Marine Corps Corporal Seth Rasmussen Memorial Highway.
Thank you, Mr. President. Your committee number 1, Judiciary, will meet tomorrow upon the noon recess in room W2 to hear 3 Senate files. Senate File 101, Post-Conviction DNA Testing Procedure Amendments, Senate File 114, Missing Persons Reporting Requirement, and Senate File 117, Shared Parenting.
Thank you. Vice President Salazar.
Thank you, Mr. President. Your committee number 2, Appropriations, will be meeting tomorrow upon noon recess in room 113. We'll be covering Senate File 68, Government-Owned Lands, Senate File 112, Anesthesiologist Assistance Licensing, Senate File 127, Administrative Rules, Legislative Review and Objection, Senate File 148, Fire Suppression and Restoration Funding, and finally, Senate File 152, Wildfire Management Task Force and State Forester. And Mr. President, if I can just make a comment, I've been in the Senate now for 4 4 years and a couple days, but I just wanted to compliment you and the majority leader for the running of today. I thought we got great work done. We did it with vigorous debate, and we did it civilly, and I hope we continue in that form, but I just wanted to give kudos to you and the majority leader. Thank you.
Thank you, Vice President. Appreciate it. All right, that's enough. Senator Barlow.
Mr. President, privilege of the floor.
Granted.
Mr. President, members of the body, if you would like, as soon as we gavel out, anybody would like to just come up and get on the dais, we'll hold up the flag, take a picture, so we can shoot it back to our troops in overseas who are serving us, and showing our appreciation to them. And I think, Mr. President, I will probably give you a week if you want to put together some stuff to send over. I'm gonna actually put together a parcel to go with it. So if that's of interest, if you're interested in the picture, we're going to do it as immediately after we adjourn. Thank you, Mr. President.
Great idea, Senator Barlow. Okay, you've heard the motion. All those in favor say aye. Aye. All those opposed, no. Senate will stand adjourned until 10 a.m. January 30th, 2025.